Mr. Puneet Dalmia, Mr. Kaushik Chatterjee, Mr. Anurag Das, Mr. Shantanu Nalavadi, Mr. Rajesh Sampson, and Mr. Bharat Anand on stage for the session.
So, good afternoon, everyone. Thank you for joining us in this post-lunch session. I think some people are still finishing up. We have a terrific panel here with both Puneet and Kaushik in terms of strategic investors, and then Anurag and Shantanu in terms of ARCs, and then Rajesh in terms of giving us the perspective of RPs. So with much ado, I'd like to just kick off. The words reporting, recapitalization, and then resolution came to mind when this government it kicked off the concept of launching the IBC and solving the distressed debt problem in India. What we're facing now is, in the context of resolution, can we create an effective market for the acquisition of distressed assets? And so what I'd like to do is really, get the perspective of the financial investors, the strategic investors first, and then the ARCs, and then Rajesh, in terms of the views of the resolution professionals. So Puneet, my first question is to you. As an entrepreneur, you approached the IBC very early on, and you have gone back to the IBC process repeatedly. So what advice would you give in terms of creating this robust market for distressed asset acquisitions? And what advice would you give to other strategic investors looking at bidding for distressed assets in India under the IBC?
Thank you very much. I think first of all, what drew us to this market was we were in the last 6-7 years, we had already been quite acquisitive in our growth, and we were looking at an inorganic growth strategy. So that was already a part of our thought process. And we were looking at almost all deals, whether pre-distress and distress was like, in India it was distress earlier, but not defined as distress because evergreening was going on. So we were in the process of looking at many deals, but when this law was announced, we knew that now, there will be a large pipeline of assets which will come in the market. So we really invested in a team which was exclusively focused on this kind of an opportunity. And I think sometimes you have to, be a little patient. And, you never have 100% certainty whether deals will actually happen, not happen, how will the law ultimately play out. But I think just having a fully dedicated team helped a lot. And I think the second thing which I would say is that many times, since you are already doing homework, you are engaging with bankers, you are engaging even with companies. Some of these companies were engaging with us even before they had gone into the IBC process. So our information and diligence, in some ways, I would call it soft diligence, was much deeper even before the process started. So we were ahead in terms of our learning curve, and we were ahead in terms of what kind of value we would be willing to put on the asset. In IBC, you are crunched for time, so if you start a little bit ahead of time, it is quite helpful. So I would say for strategics, it's a great time for consolidation. For people who already have a position in the market. For foreign investors, it's a great entry strategy. I mean, many steel companies like Arcelor, etc., who are looking at assets in India. It's a interesting entry strategy. Even in cement, I think some of the players have been looking, but their balance sheets are quite stretched. But it's a good entry strategy for MNC strategics. So I would just say three things. One, put a dedicated team. Engage with all participants and do your homework so that even before the process starts, you are a little bit faster off the blocks. And third, it's a very interesting time to consolidate and or look at an entry strategy. In order to create a more robust distressed market, I think there has to be a transparent process. And I think the government has been very proactive. As I've said earlier, it's a game changer law. Earlier the bargaining powers was with the borrower and not with the lender. This has changed the bargaining power completely. And I think transactions will happen. Only thing is that it should be a transparent process and timelines need to be adhered to. And I think it will evolve over a period of time. So if these two things are taken care of, more and more people will be willing to participate in the market and put more time and resources behind chasing deals.
Thank you. Kaushik, if I could just request you to come in on the next question. You have completed deals, through IBC, large steel, distressed steel player, Bhushan Steel. You've completed deals pre-IBC, in terms of Usha Martin. So two questions really in terms of, firstly, how is distressed M&A different from, say, doing a normal M&A transaction? And, secondly, when you're talking about doing a distressed deal, what are the key differentiating factors in terms of evaluating, do you acquire an asset pre-IBC and really try and have a bilateral type of transaction versus, the more public auction process that one encounters, during the IBC?
Thank you, Bharat. Good afternoon to all of you. I think if I were to, prioritize your questions, distressed companies start throwing signals much earlier, and if one has a strategy, as Puneet rightly mentioned, of growing and looking at it from an inorganic perspective, and if it's in the same line of business, you start getting a sense that these are companies which will one day or the other fail or face problems, not fail, face problems unless they undertake some severe restructuring. So that signal we obviously get. We also get a sense of which assets are good assets, which assets have the maximum synergies to leverage, and so on. So these were always in our radar. We do have a very strong M&A focus as far as our long-term strategy is concerned. But in India, doing a bilateral transaction, whether it is distressed or not, has often been very challenging in the sense that the promoter shareholders don't want to give up control, and because there is a fair bit of ecosystem built around companies. And sometimes it is very hard for people who have built businesses to ever think that these businesses will not be in their control. And I think one should be cognizant of the fact, because there is emotions involved in it. And so it was this which led to, actually, if I think about it, the whole evergreening process, because hard calls were not taken, but oxygen was given for another quarter, another 6 months. One reason was the banks wanted to shy away from NPA provisioning. Companies did not want to do deep restructuring. So you had this whole combination effect, and it would take a long time to possibly illustrate all of it. But I think it took a long time to figure out that the systemic problem was growing, whereas the underlying was moving towards a failure. And in some cases, it was also because of the lack of ability to raise funds, even for working capital purposes, which have led to distress. So I think when this law came in, and I must say that this has been a very significant loss since independence, and the way in which it was crafted, the way it was implemented, and the speed at which the amendments happened post-implementation. I don't remember any other piece of legislation being so proactive. So from that perspective, I think nobody in India could even imagine, and people who were evergreening on both sides were thinking, this will continue, this law will stand on its side, and nothing else will happen. But the fact is that we have, I think, a very, very strong foundation of a insolvency process in India. When you negotiate on a bilateral basis pre-IBC, you would have pluses and minuses. The pluses being the processes are under control, and one would get into negotiations with the shareholder group in terms of crafting the transaction. If you are, the negative of that is it may also get prolonged, and the negotiations may actually not end because there's no time definition. In the IBC, I think I equate an IBC to a situation where there is a fire in the building and the fire brigade has been called. And if a fire brigade has been called, there cannot be too many priorities. It is one line which needs to be addressed, one priority that needs to be addressed, which is how do you rescue the failing firm. And I think that is, in my analogy, the way I look at IBC. And therefore, everything cannot be satisfied in some ways also. Though principally IBC does say it is in the interest of all stakeholders, but fundamentally it is the people who have the biggest exposure to whom this has to be addressed to, and it is world over. The secured creditors stand the highest in sequence. So I think it is the speed, the process integrity, and the timeline which are the key success factors for a distress within an IBC. And I think that is how it needs to be looked at. Unfortunately, if you have too many indulgence on too many issues, it would get into a extended timeline, including the courts, which is why, in my view, as if I were to address this at this point of time, the process owners have to control the process, which is the COC and the RP, and within the broader framework of the IBC law, and ensure that there is no deviation. And in time, I'm sure the judiciary will come out and settle some of these nitpicking points of who can come to the process at what point in time and so on, which tends to compromise the process. But as I said, if I have to maintain a fire brigade principle, we have to ensure that it happens very quickly, because unlike in the West, where there is a concept of pre-pack, where there is a process at the pre-IBC level, where there are chances for white knights to come in, and you can satisfy the creditors and then move on to have a pre-pack almost in 48 hours or 72 hours. In India, this has not yet started. So all the questions, all the white knights are coming at the tail end of the process, not at the beginning of the process. So it's because people want to test what is somebody bidding for, and then I will be a white knight. That principle will not work, and will have to be eliminated at some point in time. If there are white knights, they have to come in the beginning, do a pre-pack, move on. There's no problem. But if it has entered the process, then that 180 plus 90 days has to be a sacrosanct. And I think the reason is again because of that fire brigade principle. You cannot let the firm burn at the cost of the process. So I think that's how I look at it from a pre-IBC and a post-IBC point of view.
Great, thank you. So Shantanu, if I could bring you in here, I really like the analogy of the house burning down, because it forces you to prioritize. And I think we've also heard from both Puneet and Kaushik about the same sorts of issues in terms of process, sanctity of the process, time frame and the like. But would you like to suggest some specific steps that perhaps we should start thinking about now in terms of attracting more strategic and or financial investors to bid for distressed assets and to achieve a turnaround?
Yeah, thanks. Yeah, so there are, I think, very broadly 7, 8 steps which we need to look at to really make this market more attractive. I think the good news is because of all what has been going on, certainly India is on the radar and people are looking at India. Obviously, every day there are new investors who are announcing their funds into India. But I would like to highlight a couple of things which we need to focus on. One is, I think, a lot more needs to be done on the quality of the IM which comes out, the data room and the VDD. IBB has recently come out with a model IM, and I think, once that comes out, it's a very good note which has come out, and really resolution professionals need to work more on it to get to as much specific details. Some basic stuffs like, if I take some examples, you often don't have the list of equipments, which vendor, which year it's bought from, what are the environmental issues, what are pollution related issues, where are state of approvals. Those things need to be certainly come into the IM. I think the second is a process which I think both Puneet and Kaushik refer to. I think the process needs to be sacrosanct, and I think that's the only thing the international investors care about. Frequent changes to the process, where the goalpost is changed or the parameters are changed, or if the timelines are too short, it just doesn't fit into any international investor's timeline. As you know, you need to call for an investor committee meetings, and you've got to go to the process, and that really doesn't play well. And you can see that in most of the deals, there'll be a lot of investors, financial investors, who actually pitch in and make the UI, but eventually start disappearing because they're just not able to cope up with the timelines and the frequently changes in the process. I think the third thing is one is to focus on is the evaluation criteria. Fundamentally, financial investors do not have the operating assets, but they are investors in operating assets. So, your evaluation criteria, which is typically a financial versus an weightage of 70-80% given to financial criteria, and the non-financial criteria, which is operational track record and other things. One is to make sure that it sort of accommodates financial investors. More importantly, I think one of the points we've been noticing is that if there's a cash on the table offer, okay, you need to get a maximum weightage to that. Okay, things like I promise to pay, things like I'm giving you X equity on a business plan, which is an Excel, and thereby you get to a score which actually tips you over a genuine offer, which is really a cash at a minimum discount, should be weighed favorably versus anything else. I think so. That's the other criteria. Third is bidders need to be carefully evaluated. I think we have all seen in the last 6 weeks, bidders who are successfully won in IBC and bidders who have won outside of IBC have failed to actually land up buying the asset, and that leaves a very bad taste and doesn't build a strong confidence with international investors. And that's really what investors would like to see change. The next one is losing bidders. Kaushik made the point. We've seen some couple of legal cases which have come out that he has a right to rebid. But really, if a losing bidder rebids, there has to be something which is disincentive. There's a disincentive there. So there has to be something like if there's a winning bidder, he needs to be paid significant breakage fee for costs, so that it really is a serious bidder who actually comes in, because if he's just waiting there to get the best offer and pip him by X dollars, that's not going to work, because that's not going to build confidence into the process, and very few investors will join the process. I think the next significant point is as the cases get out of IBC and as companies start taking over, one has to ensure that litigations which do come out where unsettled creditors still make a demand, okay, the judgments have to come in favor, because eventually what you're looking at in IBC is everything gets cleaned up. If that's not going to happen, then really, that shakes the confidence of investors and strategics and financial board. I think, and one last point is, we need to be conscious of the fact that, while there are litigation, eventually the market has to move to market forces. So there's minimum intervention from judiciary as well as state. Prolonged resolutions would only mean that, certain assumptions are made based on which I made a binding offer. Those assumptions no longer hold good. So there are very high chances that a successful bidder may actually drop out of the process even after having bid, just because closing is taking so many more days.
No, thanks, Shantanu. I think that was very insightful, and very well thought through in terms of clear recommendations and takeaways, from this gathering. So thank you for that. Anurag, if I could, just ask you about, the whole role that ARCs are now playing. So ARCs, particularly since the inception of the code, have actually accumulated a lot of debt on their balance sheets, right? They've gone out and acquired this debt from banks. So what sort of impact do you think ARCs will have in terms of the resolution of the distressed debt problem that we have? And do you see this as a very positive role that they play, where you have a handful of institutions that have accumulated this? And also, do you think that there is room for international funds to play a more direct role in approaching distressed assets, or do you think the ARC structure is really the way forward?
Well, I'm going to try and address this in two dimensions. One is just take a step back, big picture. I'm not yet an ARC expert. I've come on board recently. The general objective is that a new age ARC in the context of the code should be a distressed fund manager. And so the one distinction I think of is it's a largely public sector financial system where the debt exists. And if you're transferring that debt to private actors or other parties, perhaps in the context of supervision, it can't hurt a little bit to know that these are regulated entities that have some role to play. Where that goes in future remains to be seen. For now, Indian bank loans transfer most easily and practically into the ARC format. But the ARC universe is transforming. I mean, each of the investments we've made and the ones we're looking at are not really in the mode where they used to be in the past. A couple of ARCs have been active and been participating in these resolutions and have done what is an important piece of the distressed debt market globally, which is you aggregate the debt. You don't aggregate all of it in one hand to try and have one party take one approach. You want some level of debate, discussion, and the evolution of the best possible approach to a resolution with several voices at the table. A little bit that is going to start to happen. In the context of SARFAESI, obviously the restrictions on transfer ARC to ARC, restrictions on how much of the debt you could own before you have a right more or less to start aggregating. And bidding is a very costly process. The idea that a bid is a price discovery process where everyone should show up for free and then other people can bid ROFRs and argue, etc., are deterrents. But I think if you think of where IBC is at, I think everything that a code could do, bar the 4 or 5 things that are potential improvement factors, is in place. In fact, based on what it is, I think it's batted so far above average in what it's achieved that it's hard to argue with any of them. There's lots of little things we can all pick at. Some of them I think are natural evolution matters. Past panels mentioned secured creditor classes being separated from unsecured creditors. Broadly, some classification of creditors is going to be required. It'll probably happen. There's a point later, but I'll brush at it now, which is, will differential claims behind your holding lead to differential outcomes? And they should. Whether we choose to make separate classes, each of which needs to vote on a certain basis, and whether a judge needs to cram down and say you're just being too greedy, it won't work, is something to be debated. I think with the complexity of the cases that have gone through the system, I think the infrastructure is prepared. It may be short in terms of size, and maybe marginally short in terms of experience, but we're there for all practical purposes. So now to go back to your point of, is this direct or indirect? I think some version of an eye is going to be required in the system until we get past a predominantly public sector banking system. Which then brings us to what are the factors underneath? I think there's both big picture factors that are the attraction. There are some small, minute factors that are deterrents. But they're not really IBC driven in as much as process driven. The process by which auctions are held. I think the timeline in IBC poses a particular challenge, and Puneet commented on that, Kaushik commented on that. We often don't know too much about an asset. We've become pretty good over time at learning what we need to on a short time frame, putting things in process. But the process as yet is crunching that time to 2-3 weeks for us. So for players like us who tend to come in, need to examine the asset, value it, put together a team if required to execute a turnaround. That timeline's pretty crunched. There's, sometimes I hope that the IBC process expands from 6 months to a year, but creates a 4-month window within which this maximum realization exercise achieves stronger impetus. So clearly we need more time. Right now we just try and start earlier, but sometimes we just don't have enough time, and then we spend a lot of time and find we can't do much. But I think getting the banks to clean up how they sell will help a lot of players come to the table, add more voices in a COC, and if we just look to the rest of the world, the process is pretty simple. There are some original lenders who get to enjoy the benefit of a slightly better recovery on average, or a much better recovery on average, by staying at the table through the process, but it's a real market. Some people decide it's going to be worse by staying in, so they sell to other parties. And when you achieve on average a better outcome by involving new voices, new decisions at the COC process, then the guys who stayed either enjoy the benefit or the disbenefit, but on average they get a benefit. So I think it's very important to try and see how more than one voice and how more than just the original lender voices are heard. In the US, one of the things I've liked that I see in contrast with Australia is, in Australia you can have a huge COC. Almost every bank sits there. And the same dynamic that holds out a resolution pre-IBC sort of shows up in an IBC insolvency type context. While in the US, as they always say, don't show up with a big voice unless you have a big club, right? If you've got 80% of the debt at the table. I've been in situations where we basically throw out the guy who's got a little piece. My take is go away, it doesn't matter, we're going to vote you out anyway, don't make a noise here, go home. And some of that's required because the COC process with all the guys sitting there is chaotic. In a commercial process, the overall objective I think will be better served by excluding the little guys. Sometimes we'll be the little guy because I own 1% or 4%. And then my vote doesn't count, and so my voice shouldn't count much. So at some point, I think potentially including operational creditors as general unsecured claims if they're really large. Whoever has a large claim should be able to come. Getting the operational creditor claims to trade, I think, will follow getting the bank debt to trade more. But at some point, 3 years, 5 years down the line, we'll have a market like others where OCs will sell their claim, people like us will buy them, will value it differently based on where it stands in the hierarchy. And I think adding more voices with the correct value being gleaned for the respective creditors will improve the process. So I think lots of the strategic pieces are a draw. All the little pieces that mattered from an IBC standpoint are more or less sorted out. Some are getting sorted out. The big picture ones are the 3, 4 we've talked about. But now we're at the point where all the little stuff that is actually procedural, regulations from RBI, who sells, who buys, how you buy, where they issue no due certificates from. There are cases where a bank will assign you the loan and issue a no due certificate to the borrower. What recourse do you have? You can sue them. That goes to a different panel, or maybe it comes to NCLT. But some centralization, automation, cleaning up the process, creating a central depository, saying put all the documents there, now it's a record. Those kinds of things I think will start to improve. That's what scares most people who are engaged now.
Thanks, Anurag. I think very helpful, very broad comments. Rajesh, if I could, just bring you in here. So the CIRP process has fared quite well in some sectors, like particularly steel, cement. What do you foresee in terms of other asset classes, particularly real estate? And I think the previous panel touched upon power, but what would be your predictions there?
Yep, some crystal ball gazing. So Bharat, thanks. In fact, I think you introduced me as the RP on the panel. I have to clarify that I am actually an accidental RP, and that's a clarification that I always make because I'm actually an RP by virtue of being an M&A professional in a sector which had gone into distress a few years back. And I've strongly come to the conclusion that the best way to resolve distress, divestment in this country, it continues to be the code. With all the issues that we've seen over the past few months, I think it continues to be the code, the best way to get this to happen. I think it's a valid point, Bharat, about sectors because people like Anurag, I guess, are tired of hearing me saying this. But I keep saying that last year was the year of steel. And this year I think is going to be the year of, for sure, power, a sector very close to my heart. Real estate, I think, I know that a lot of lenders are really hesitating now to trigger cases in real estate for obvious reasons, but I think that they will come. I have to tell you, when we embarked on this journey as RPs, when we came into, for example, Bhushan Steel, when we came into Binani Cement, there was a lot of trepidation, and we were all wondering what would happen. Will employees cooperate? What will be the view of lenders? How will we run this company? Blah blah blah. There was one question that never arose in our minds. There was one question that we never actually stopped to think about, which was, will we find a resolution for this company? Because I felt it was fait accompli from day one. I felt that there was a market for these assets as an M&A guy. I knew there were people who would be interested in this. Unfortunately, where we stand today, when I look at power and, to be honest, real estate as well, I can't actually say that with the same level of confidence, but for two very different reasons. And if you permit me, I'll just spend a little time, because I think they're two actually very different reasons. So let's talk about power. I think a sector that I'm deeply involved in right now. Clearly, if things go the way that I think they might, we will see a lot of admissions in stressed assets in power, mostly on the thermal side. We have already seen multiple attempts to get these assets resolved outside the code, maybe a couple of successes, and I think the bulk of them, my guess is that they will probably get admitted. And the question is, do we have enough resolution applicants? And my honest conclusion, in fact, I'm very curious to hear the view of some of the investors on this panel. But if I were pressed to name any global IPPs that are today anxiously following the thermal power opportunity story, which I think is a very good opportunity story, by the way, personally, I'd be hard pressed to name any. What I am seeing is a lot of financial investor interest. That's the irony. I am actually seeing a lot of financial investors who say, because of the volume of the opportunity and the fact that we have this code, which hopefully should enable us to take it to close, this is an interesting opportunity for us. We would like to participate. We've brokered several such conversations between investors and lenders. But here's the catch. The huge majority of them will not be able to participate without piggybacking onto a strategic player. And when it comes to strategic players in the sector, there is a real lack. We are effectively back to a very limited set of domestic players who I feel can participate. And so, unfortunately, Bharat, I'm actually going to make a suggestion which I know has lots and lots of people on opposite sides of the table. But the irony is that in the power sector, I personally believe that there are potential resolution applicants who perhaps will not be able to participate in the process, in some cases for no fault of their own, because of the way that we currently interpret and operate Section 29A. So I know that's a huge issue, and I know there's a lot of debate on that in the previous panel as well, but this is a sector that I think that is actually going to get affected by this. When I talk to, I'm not aware of too many cases where, for example, if an asset were constructed at, let's say, 7 crores a megawatt, I don't know how many of these cases, your 7 crores a megawatt would be a totally genuine number. Perhaps it should have been at 5 crores, perhaps it should have been at 6 crores. Here's the catch. In most of the cases, I don't believe the cost was really a reason for the project going bad in the first place. There are extraneous factors which I'm not sure any other sponsor could have handled in many of the cases. So that is one thought I have is, on the power sector. It's a very, very topical issue right now, because I think a large number of a huge volume that we're going to see for the next 1 year is in this sector. We need to think about it because we have tried. We have spoken to lots and lots of players, and I have a feeling in this sector, we will have the capital to come in, but it may not be the right kind of capital. It is capital which in isolation cannot come in. It needs some of the domestic players to back. And we have to see if there's a way to enable more domestic players to actually play in this space, the ones who today may not be able to participate. So that's one point. Sorry, but I'll change track completely on the real estate sector. I'm actually not a real estate expert, but I happen to have been the RP on a reasonably prominent real estate case. And I found out one thing in the resolution process in real estate. A couple of things, actually. One is, a lot of real estate cases, especially residential real estate cases, economically, it's very difficult to see how a resolution applicant can see value in some of these cases. That is unfortunately a fact. But there are cases where there is value for a resolution applicant to come in. But we have another issue there, which is, I think, specific, or at least very, very specific to the real estate cases I've seen. But I have a feeling that as we progress, it'll become more relevant for more cases as well, which is that a lot of cases, people who are interested in finding a resolution for that business, in this case it was the real estate business, are not interested in finding a resolution for the corporate debtor. They are interested in finding a resolution for the business. And what we found out in practice was that we had situations where investors were willing to come in, but the way the law works in India, of course, you have to find a resolution for the corporate debtor. There is a requirement to, obviously there are many mandatory requirements for resolving the corporate debtor. In a lot of overseas jurisdictions, that need not necessarily be the case because the standard method of resolution actually is through what we would consider as a slump sale. Somehow the way things have happened, and I think it's because of the kind of cases that we had over the last year and a half, we've all assumed that the corporate insolvency resolution process is actually the corporate insolvency sale process. It's actually an M&A process. We basically have a new owner of the corporate debtor. But what if nobody is willing to take over the corporate debtor, but is very happy to take over the business and settle part of the liabilities? What do we do with the corporate debtor going forward? We had, in our case, in fact, a potential solution that we never got to actually implement because I think of judicial intervention. But we did have applicants who were willing to take over the business, and we actually needed to leave the corporate debtor back in the hands of the financial creditors, in fact with 100% or maybe 99% with the financial creditors. And there was a big question mark as to whether this is actually compliant with the code. There was a big question mark as to whether we were taking off all the mandatory contents of a resolution plan. There was a big question mark as to whether individual COC members would even accept a plan of this kind. But I suspect going forward we'll have to think about this because I can see a lot of cases that will be resolvable only by doing, non-sale mechanisms like this.
No, thanks, Rajesh. I think asset deals and the previous panel had a lively discussion on the force majeure out for power. So that seems to be a theme resonating today. If I could just ask maybe Puneet and Kaushik, both of you, jointly, when in terms of the resolution plans, in terms of implementation risk, what have been some of the greatest challenges? What has been your approach towards mitigating some of those challenges? And is there a gap in the law in terms of the genuine rehabilitation of companies? So, for example, do we need a single window clearance system or something along those lines to enable these plans to be implemented?
So first of all, I think I want to look at this at a country level. I think at a country level, we were facing bigger challenges where debts were being evergreen, problem was being understated. And I think at least that has come to the fore where at least there's clarity of what is non-performing and how it needs to be resolved. So yes, there are challenges now, but there are smaller level challenges that we are dealing with. So I think at a country level, this is a game changer, and this is something which is a really, transformational law, which will go through its teething troubles, which will get refined and more sophisticated. But, having said that as a context, I think there are a couple of things which are very specific, which we have faced. We've been involved in three situations specifically. And I think there are 2 or 3 things that I want to, talk about. One, I think there is clearly litigation risk. And as I said, this is new law. So even after a resolution plan has been voted upon and bank guarantees has been deposited, there's still no certainty as to whether the transaction will close or what time and how long it will take. And for that time, all your resources are blocked, time frame is blocked, etc. And I think on this, the real debate is value maximization versus time and process compliance. And as Kaushik was saying, that there's a fire brigade principle here. And I think at a country level, we need to think, deals, 1 or 2 deals can happen whichever way. But at a country level, I think we have to read these 2 aspects harmoniously. How do you maximize value in a certain prescribed time? So often in India, we are, and maybe elsewhere in the world as well, it's difficult to calculate the cost of delay. You know, so imagine if RP is running a company, and I have nothing against RPs, but you know, if RP is running a steel company or a cement company, you know, maybe they will be, in all likelihood, they will be less astute operators of the asset as compared to, you know, Tatas or JSW or Arcelor or in steel, Dalmia, Ultratech, whatever. You know, so I think more natural resources could be consumed. They could, you know, create, they could be lesser volumes, which could lead to lower revenues for the state. There could be lower bonuses for people. So I think at a national level, just delay causes a cost, which is often very difficult to estimate. You know, so I think these two things, value maximization versus you know, time, they have to be read in harmony. And I would submit that, you know, you have to maximize value, but in a certain prescribed time with a certain prescribed process, which is identified upfront. So I think this is one issue. And most of the litigations, if you see, other than 29A and who can apply, who can participate, who cannot participate, are mainly due to this. I think the second, you know, second question, you know, which we are facing in some of the cases, is that there are in industrial assets, there are states also who have to be who have to, you know, implement certain aspects of the resolution plan. You know, so for example, you have to renew mining licenses because they've been cancelled, or you know, you have to take certain write-offs because there are statutory you know, liabilities which the state has no say on, but you know, it's sometimes you have to, you know, continue with the incentives which were a part of the process. So in certain situations, we are facing that states are saying, look, we are not signatory to this agreement. This is an agreement between some court and a, you know, company. I am not a signatory to this agreement, so is it binding on me? So that is a question which is coming up in, you know, of course, they want the project to restart, employment to be generated, revenue to kick in. But, you know, is this binding on the states or not? Is one more question which we are facing. Then there is one more third level of question. In one specific situation, the insolvency process has been completed, but there was a winding up petition which was filed against this company before the insolvency process started. So now there is a legal question as to whether the winding up petition should take precedence or should the insolvency process take precedence. And the insolvency process has been completed, yet this litigation is going on. You know, so now the High Court has ruled that yes, IBC has to take precedence, but you must involve all operational creditors to also have a say. And so it has gone back into one more you know, level of delay. And you know, this has been dragging on for 6 to 9 months. So I think there are teething troubles, but I would say there is a very proactive government and a proactive dialogue to resolve these issues. And I think that is very heartening. So if you look at the, you know, whole evolution of a country, I think this is a blip in that timeline. And overall, I am personally delighted that recoveries are bigger, more than what we expected. Timelines are also, you know, not as bad. They could definitely be improved. But and overall, there's a, you know, very positive and engaging dialogue with all stakeholders.
I just wanted to add a couple of comments on this system implications. So I think from a system-wide standpoint, I think we need to recognize that there are narrow slivers at all points in time where strategics are very interested. There is a reason why globally there are non-strategic investors that tend to make their living like we do, helping resolve these sorts of situations where the resolution on average, on a system-wide basis, benefits a little bit by having everyone involved. Now, obviously, to some degree, the strategics don't like the idea that people like us kind of get in between, because if we don't, then you can get it slightly cheaper as a strategic. But on balance, there's a vast number, and in India, I think it's very relevant because we're seeing that next tier of assets where the strategic interest is going to be of a totally different level. These initial kind of gold-plated assets that are hard to create in today's context, large land holdings, 6-year commissioning timelines, variety of approvals, the next tier are not as complex. And to help resolve each of those, we'll need to wait in the process in some form where it becomes feasible. You know, the evaluation matrix point that was made is very valid, which is if you've given weightage to a factor, and I'm looking at a particular insolvency where we're starting to say maybe we should bid before IBC, resolve before IBC, not because there's anything about IBC that puts us off. I find almost every element attractive. But the process, the way it's being driven right now, the COC sits down, 40% of the weight is to cash up front. 35% of the weight is to cash later. As a credible investor, we're not going to promise cash later that we're not good for. Almost by definition, our bid of cash in that second bucket is money we absolutely seriously intend to pay, or we wouldn't put a number there. But I'm up against people who will bid a number in that 35% weight, which they probably do not intend to pay. So now you're stuck with saying, I want to pay $200, but I've got to populate both boxes. If I put $200 in my immediate upfront cash, which we're willing to do, those 200 rupees are going to go to the creditors right up front. But I get a 0 score on the deferred piece, where the highest on that factor, on that 35%, scores the highest 35 points, and 35% of the weight on the evaluation goes to that person. Funnily enough, in this particular situation, the RP said to me, well, why don't you, we can change this boundary to 3 months and later. So if you're keen to invest all the money up front and pay it, break it into 2 pieces and put the deferred part in the 4th month versus 4 months up to 3 years. So now I'm competing against somebody where we're paying 200 rupees. We intend fully to pay the 100 up front and the 100 later. We would have paid the 200 up front. But the other party is able to come in, and if they're not serious about the deferred payment, which they don't have to pay today, can pay 100 today and promise to pay 600 later, which will never materialize. So I think the importance, as the next tier of situations looked at, feeding back into the implementation of plans, I think the easiest way to get away from the issues with implementing a plan is to start to shift towards something where the implementation of the plan is the bidder's problem. It's not the problem of the seller. The seller should be trying to sell these for more or less maximum value up front. And then on average, responsible bidders will come in who will make market-based bets. If they're wrong, they'll lose money. Over time, they'll go out of business. And the ones that succeed will be people who have bid sensibly and have bid plans they stuck to or improved on or delivered on average. So I think the intention and the idea is good. The implementation driven by an RP process where everyone was new to it says, let me be highly predictive up front and know that the payment stream coming in years 3, 4, 5 has a 35% weight and is being deducted from the rest. So I think as we think through these sorts of processes, we'll have to weigh the ability of the system to rescue a large number of assets, where by and large you need an intermediate kind of firefighter or a surgeon to come in and stabilize it before the rest of the world be interested.
Yeah, so I just want to supplement some of the points that Puneet mentioned. It's been an evolving process, and I think when we started off with Electro Steel, it was possibly one of the first ones where we bid for. And the rules of the game were not clear from the COC perspective, whether it will be 1 round or 3 rounds or 5 rounds. And then when we all bid, and then there was company which bid highest, and we were told by the COC that's the government procurement rules, and that's about it, which is fine. And I think subsequently the process notes became more and more robust, and I think you have to accept that that's part of the journey. I think for a country like India, where you need to kind of avoid controversies and conflicts and litigation, it may be worthwhile to put everything onto a same platform, to have a qualification of bidders and then put all of them online. Because, like you see in telecom auctions or various other coal block auctions, it's now without any noise. Why? Because it's now online. You run it for 2 days, 3 days, especially if the value maximization of the secured creditors or financial creditors is something which is the most important priority. So therefore, there will be no intervention of the kind of thing that Anurag mentioned, of what is the weightage upfront versus the weightage later. Because many times I've seen in the ones that we participated, subsequently the weightages do get changed, because somebody on hindsight sees, oh, that guy's got a higher weightage by putting more equity to get more points, I match it up or put a little more higher than that. So those kind of things are happening. The best is to become completely on a platform where nobody has an interference. So you bring everybody, like 10 bidders put in the initial bid. Based on the qualitative, you bring down to 6, 5, 4, whatever be the number. And then you say these next 3 days they will go on an online auction on the value maximization on one point, which is basically what is going to be the waterfall as far as the creditors are concerned. If that kind of thing happens, I think in an Indian context, it would possibly take away a lot more of the judgment and movements that is happening and the consequent litigation that is following. So that's one point that we thought it's important. Second area which I thought is something that we always struggle is many of these companies are listed companies. And if you look across world over, whenever a company is being admitted for insolvency, immediately the shares get suspended. It is no longer, because you are then creating a speculative market, because if your debt is actually not being recovered, then equity is by theoretical derivation is negative, and therefore it is suspended for trading. On the completion of the resolution, it restarts. But in India, you have a lot of pressures around many stakeholders where this continues, and depending on the headline of the day, it'll get speculated. So that's one artificial market which I think needs to be taken out, and I would believe that over time the regulations will refine it to make it work. Because what happens is post-insolvency you get into trouble as to what you want to do with that speculative trade. The third thing which I think is important is and I think Shantanu mentioned it, the quality of the IM and the quality of the information is really something that needs to be worked out, because people who are coming in from outside within a short period of diligence and a short period where all of these have to be kind of addressed needs to have good quality information. So in a manner speaking, if, and this is, I would imagine, it would be more important for financial investors than strategics, because strategics at least would have a good lay of the land as well as the business. But for financial investors, it is a challenge, and if you want to create a market for these assets, I think quality of information is very important.
Just a housekeeping announcement. We have to conclude this panel a few minutes before 2:30. So while I take final comments from my panelists, can I just get a show of hands in terms of Q&A from the audience? Because based on that, so we have one, just bear with me, we have, just in terms of house rules again on asking questions, please identify yourself. As a panel, we will retain some discretion in terms of whether we will answer specific questions, because many people here on this panel are involved in legal processes that are subject to confidentiality, so you would permit me that much leeway. But we have one question. Any other questions from the audience? So just bear with me. I think there is one, two. So just bear with me. I think, Anurag, you had a quick comment to make, and then let's open it for the Q&A.
I think I'll take a pass. I was just saying I think it's fine to leave stock listed. There's a few countries that do that in IBC. It's for the market to decide, and I think it's much worse to curtail liquidity in a market that functions in general than to adjudicate that liquidity by taking it away in a specific situation. If the market thinks it's worth zero, that's fine. And if someone's speculating, they'll learn their lesson in due course.
Yes, sir.
Yeah, I am Satish Kumar, Joint General Manager of South Indian Bank. In case of insolvency proceedings initiated by the operational creditors also, the charges cost towards the same. Is it fair on passing on the cost to the financial creditor? That's some of the RPs. They pass on this expenditure because, who should bear the cost? That is one issue. Then another one, in the case of classification as willful defaulters, some of these borrowers take the plea that, there's moratorium under resolution process. That during that period, we cannot classify them as willful defaulters. So these couple of questions, if you can just throw some light on this, I'll be happy.
I'm happy to say I think it's perfectly fair. Once it's insolvent, if someone initiates insolvency, everyone's going to bear their cost. It's a good thing it starts. I think it's, you know, if financial creditors did not get it started, the law says, I think correctly, that it should be possible to get the process started. When it starts, everyone's going to bear their fair share of the cost. So I think it's generally good that anyone who's suffering should be able to initiate insolvency proceedings.
And, sorry, would you just mind repeating your second question, please?
Borrowers as willful defaulters.
Yes.
Some of them take the plea that, you know, during the moratorium period under insolvency proceedings, they cannot be classified as willful defaulters by banks. Is it true? I just wanted to know. Because does that give them an insulation from this?
No, I think, you know, to my mind, there's no such exemption from the classification of a willful defaulter during the moratorium period, if that finding were to be arrived on the facts.
Okay, thank you.
So, I am Harish Chandar from Edelweiss. My question to the entire panel is, how to enhance the pool of bidders without tinkering with Section 29?
So I think personally there's a lot of capital waiting to come into India. And you know, there was a conference organized like this in London, and there were like a lot of interest from financial investors. And I think the total you know, supply of these assets is somewhere in the region of you know, $150 billion odd dollars, and out of which probably 30-40 billion will already get resolved due to these big cases. So apparently there's like $200-300 billion of distress money, you know, which can come to India. And I think if there's a transparent market where there is confidence that things will get resolved quickly, high quality information, you know, I think a lot of money will flow in. So I think it really depends on how you set up the process. Too much complexity in evaluation, this kind of, you know, thoughts, even though they may not be gaming, but if people think that gaming can happen, you know, then it just deters investors from spending time. There are so many opportunities around the world where people, you know, can spend their time. And to prepare for such bids, it will cost you you know, $1 million, maybe $2-3 million for large bids. Why would somebody spend time and resources unless they have, you know, confidence? So if we can provide high quality information, if we can give like high level of confidence that this will be a transparent process and a simple process, you know, then I think there'll be a lot of people willing to participate. India's story is well accepted, well sold. People really believe in this market and the long-term potential. And this is an opportunity of a lifetime in many ways. So there is enough supply of capital and enough bidders. We just have to set up the game in a manner that it's simple and transparent and high quality information.
Yeah. I think a couple of other points are, one is the current round of litigation should play out, because I think everyone is waiting to see what's happening. So if really the judiciary gets this out in the quickest possible manner, then one would know that this is a lay of the land, and obviously, like Kaushik mentioned, how to improvise on top of that. Maybe online auction could be the next possible way to bring more transparency. So I think that's one. And the second thing is, I think the judiciary bench strength should increase. As you can see now that admissions itself from applications are getting delayed, and that's not good for the system. So if both of these could sort of get sorted, I think at least you'll see deals coming into the IBC, and in parallel, if the process gets strengthened and tightened based on the learnings and the judiciary pronouncements which have come out in the 12 and the other assets, I think that will go into a long way in bringing confidence and getting investors interested.
I'll just quickly actually, we don't have time.
Yeah. So you know, if you don't mind, we're sort of 1 minute to the end of our panel. Certainly, you know, if I could just make a quick comment, what we're seeing in our business at least is foreign distressed funds look at loan trading through ARCs, and that seems to be on the rise. And I think that's a good sign. I think if those processes are well run, then perhaps there'll be another substantial source of capital looking at Indian assets. But with that, ladies and gentlemen, if you could please thank my panel for my esteemed panel for their contribution. I'm sorry we had to cut it a bit short because of lunch, but thank you very much for your time.